Hi cadets! There are many classifications of criminals, and one of the classification of criminals that we learned from the previous discussion is the classification of criminals according to Dr. Cesar Labroso. But today, what we are going to learn is the classification of criminals according to the revised penal code. So for you to have deeper understanding and for you to have guidance during the course of the discussion, I'll be sharing to you my slides. So there are four classification of criminals according to the revised penal code. One is recidivism, two is quasi-recidivism, the third one is habitual delinquency, and the last one is habituality or reiteration. So what we are going to do is for us to have differentiation, an equivocal differentiation between the four, we will be arranging each classification according to requirements. So we'll start with the first classification, which is recidivism. So a person who is considered as a recidivist is one who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime embraced in the same title of the revised penal code. So based on the definition, we can extract two requirements. One, the person should be previously convicted by final judgment of the first crime. And number two, the succeeding crime is of the same title within the revised penal code. Now take note, if you will take a look on criminal law book 2, you can actually find the definition of each crime. And in each crime, you can find attached punishment, attached number of years of imprisonment on that particular crime. And these crimes are arranged into clusters or by titles. For example, for treason, espionage, and piracy, they are clustered in the title Crimes Against National Security. If we will go to murder, homicide, parricide, infanticide, these are crimes clustered under the title Crimes Against Persons. And if you will take a look, robbery, theft, these are crimes clustered again under Crimes Against Property. So basically, the titles under the revised penal code or in the criminal law will be the basis in determining whether the person qualifies for recidivism or not. So, for example, if the first crime, the person got out from prison, committed homicide in the second crime, the person shall be considered as a recidivist. He will qualify for recidivism simply because if we will compare murder and homicide, as far as title is concerned, these two crimes belongs to one title, and that title is Crimes Against Persons. But if we will take a look on example number 2, the first crime being committed is murder, but the second crime being committed is robbery. So in this case, murder is crime against person, while robbery is crime against property. So in this case, the person shall not be considered as a recidivist. The second classification of criminals is quasi-recidivist or quasi-recidivism. Quasi-recidivist is one who commits another crime after having been convicted by final judgment of a crime before beginning to serve such sentence or while serving the same. So we have requirements. Again, based on the definition, we can extract requirements. Requirement number 1 is convicted by final judgment of the first crime. The only difference between quasi-recidivism and recidivism is on requirement number 2. Because in recidivism, the person committed the crime after, or the person committed the succeeding crime after serving the sentence. But in quasi-recidivism, before the person, or while the person is serving sentence inside jail or prison, he committed another offense or another crime, which will qualify him for quasi-recidivism. Example, if the first crime is murder, and while serving sentence inside prison, the convict committed slight physical injury, in this case, the person is a quasi-recidivist. But if we will take a look on example number 2, the first crime is murder again, but the second crime being committed was been executed or executed after the serving of the sentence, and the crime is slight physical injury, in this case, the person will not qualify for quasi-recidivism but rather recidivism. Why recidivism? Simply because, again, slight physical injury in this example was committed after serving the sentence. In quasi-recidivism, it entails that the second commission of the crime must be done before or during the service of the sentence. The third classification of criminals is habitual delinquent. Habitual delinquent is one who within the period of 10 years from the date of his release or last conviction of the crimes of serious physical injuries, less serious physical injuries, robbery, estafa, or falsification is found guilty of any of the said crimes for the third crime time or oftener. So based on the definition, again, we can extract three requirements. One is that it has to be within 10 years from the date of release from prison. And the person committed a crime exclusive to the following crimes only. One is serious physical injuries. The next one is less serious physical injuries, robbery, estafa, and falsification. And the third requirement is that the person is found guilty of this in any of the said crimes for the third time or oftener. So meaning, even if requirement number one is present and requirement number two is present also, but the person committed one of the crimes stated therein, but the commission was the second commission only, or the crime being committed was second time only, then therefore that person fails to meet the third requirement. So he shall not be considered as a habitual delinquent. For example, if the first crime is slight physical injury, and the second crime is, and again, the same, slight physical injury, and the third time is serious physical injury, in this case, the person will qualify under habitual delinquency because serious physical injury is one of the crimes stated under under habitual delinquency. But if we take a look on example number two, the first crime is slight physical injury, but the third crime being committed is kidnapping, and kidnapping is not part among the list under habitual delinquency. In this case, the person shall not be considered as a habitual delinquent. Last classification, reiteration and habituality, where the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for two crimes to which it attaches a lighter penalty. Previous offenses must not be in the same title in the revised penal code. So basically, the only difference between recidivism and reiteration is requirement number two. Because if we will take a look at it, if we will examine it carefully, they have the same requirement in number one. Recidivism and reiteration requires that the person should be convicted by final judgment of the first crime. The only difference is that in recidivism, the subsequent offense or the succeeding offense must be of the same title of the revised penal code. While in reiteration, the subsequent or the succeeding offense must not be of the same title of the revised penal code. So if we will take a look on the example number one, slight physical injury, first crime, second crime is theft. Between the two, slight physical injury and theft, they actually differ in terms of clustering under the titles stated in the criminal law book 2. Because slight physical injury is under the title crimes against person, while theft is under the title crimes against property. So basically, the person will qualify under reiteration and habituality. But in example number two, the first crime is slight physical injury, but the second crime is homicide. So again, if we will compare these two crimes, slight physical injury and homicide are crimes that are clustered under one title, and the title is crimes against person. So you shall not consider the guy or the individual as qualified under habitual delinquency, under habituality or reiteration, but rather the person shall be qualified under recidivism. Why recidivism? Because again, slight physical injury and homicide are two crimes clustered in the same title of the revised penal code. So those are the four classification of criminals according to the revised penal code. And this classification of criminals will actually affect the number of years of sentence, the punishment of a person who has been found guilty of a crime. So I hope you learned something from the four classification of criminals. And if you like the video, I hope you will click subscribe so that you will be notified of some videos related to criminology. Thank you so much for watching.